Now call to order the City of Daytona Beach Special Magistrate Proceedings for May 13, 2025. At the outset, I've reviewed and approved the April 8, 2025 minutes. Do we have any announcements before I proceed into this morning's agenda?
Yes, sir. Starting on page number 4, case number 10, SMG 05-25-81 for 220 Arlington Avenue is in compliance, May 12th, 2025. Page number 5, case number 13, SMG 05-25-84 Orange Avenue parcel is in compliance, May 12th, 2025. Same page, case number 16, SMG 05-25-88. It's a South Lincoln Street parcel, compliance, May 8th, 2025. Page number 6, case number 17, SMG 05-25-89 Green Avenue parcel is in compliance, May 12th, 2025. That's everything.
All right, well, all those representatives for the City of Daytona Beach will be testifying at this morning's proceedings. Please stand and be sworn.
You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth? Thank you.
Okay, we're going to take one case out of order, case number 5, Sotway LLC, Series 2. Yes, sir, if you would please state your name and be sworn by our secretary.
I'm Sindar Singh Kohli.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
And what is your affiliation with Sotway LLC Series 2?
I'm the owner of the building, please.
Very good. Do you agree these violations existed or occurred as stated in the notice of violation?
I received the notice.
All right, then I find the respondent in noncompliance. Madam Inspector, what should a reasonable amount of time be for the respondent to come into compliance?
The building is already painted and I'm going to get the awning done, but I cannot find the company until August. They say they are fully booked up. But I'm going to remove the torn awning, I'm going to get removed, so then it will be
All right, well, let's hold off for
compliant.
just a second. Why don't you give me a rundown here on what we're dealing with and what's been accomplished
Good
today?
morning, Inspector LaWanda Domingo with City of Daytona Beach Code Compliance. My credentials are on record. So this case opened December 5th of 2024. The owner was first notified December 16th of 2024 for violations of overgrown landscaping, weeds, trash and debris, dirt and grime, deteriorating paint on the walls, and damaged awnings. The property is still in noncompliance, and I'm requesting compliance by next cutoff.
Okay,
I did do a reinspection on May 9th, and I did see the painting crew on site, so they're actively painting the exterior walls. There was just some communication about the awnings that I was given, so next cutoff as a checkpoint for the progress on the awnings order.
all right. Is it Dr. Cole
Yes, sir.
or Coley?
Kohli.
Coley. Okay, Dr. Coley, the city seems to think you ought to be able to have this done by June 4th, and you're telling me you have a problem. What is the problem?
I contacted one company to change or repair the awning, and then I contacted 2 more. They say they cannot come even to give estimate before August. They are fully booked up. So if I spoke to the inspector, she says that if I get the torn awning removed, I would be in compliance. So I would get it done.
if you get the tall awning removed.
The torn,
Oh,
the torn awning.
Okay, I'm sorry.
okay.
And,
It's on the other side. They're showing the picture of the front. There's a picture of that
That
one.
one.
okay, and is the awning the last thing you have to deal with?
Yes.
And getting the trash and debris and rubbish out of the
Okay, well, here's what I'm
landscaping.
going to do. I'm going to order you to come into compliance by June 4 of 2025 or be returned to the special magistrate for consideration of a fine of up to, let me stop and start over. I'm going to enter a partial order requiring you to come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Partial compliance will mean doing everything here and removing the torn awning she's talking about.
Yes.
And I'm going to require you come into full compliance by September 3, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. In other words, okay, get everything done. You've told me you've already got a lot of it done. Finish the rest. Remove the torn awning she's talking about. Have all that done by June 4. I'm giving you till September 3 to get the awnings replaced. Because I don't want to look at just a frame for an awning that's sitting out there after we've removed the torn awning, which I assume is what we're going to be looking at.
Yes, sir.
So I want the job done. I understand you're having trouble getting people to help you with it. I'll give you time to figure that out. Okay,
Thank you very much.
all right. And please keep your inspector posted as you go along as far as everything that's going on.
Yeah.
Because if you end up running into more awning problems and more delays, she will be your best friend if you need additional time.
Thank you.
Just as long as she tells us you've been communicating with her.
Thank you.
Good luck to you.
Thank you.
Okay, case number 1, Adams Investment Group LLC. Not seeing a respondent, what say the city?
Good morning, Mr. Vakelja. Inspector Garcia, credentials on file with the city. This complaint was received as a complaint for violations of trash and debris, trash and debris, weeds and damaged fence, inoperable vehicle, dirt and grime. The certified letter was posted on January 22nd, 2025. Compliance due date was February 1st, 2025, and last day re-inspected was yesterday. Staff recommending a finding of non-compliance, compliance by next cutoff. Everything was taken care of except for the vehicle. It has a tag on it. It did say 2025, but when I ran it, it says expired as of 22. So that was the only thing we have to check and make sure that it is correct. This tag here, which Sergeant said she would run it now. And if it comes back good, then we can put in compliance. She's running it now, and if it comes back good, we'll put in compliance. If not, then we'll do the next cutoff.
All right, so you want me to just,
It's Wisconsin, G Gulf, X X-ray, H Hotel, 284.
while she's doing that, noting the absence of the respondent based upon our inspector's testimony as well as the photographs presented, I find the respondent in non-compliance.
The city would like to note that the respondent has been properly notified.
Can you put the tag again? Okay, that's what I thought. So we're gonna do the next cutoff, and I'll get them to come and get that registered before.
Having found the respondent in noncompliance, I order the respondent come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 2, GEA Seaside Investments Incorporated. Anyone here for the respondent? What say the city?
Inspector Curtis Wiggins, Code Compliance, credentials on file. This case was opened January 24th, 2025, a field-generated case for faded paint, dirt and grime on the building and retaining walls. First notice received was January the 29th, 2025. The compliance was due by February the 28th, 2025. Last date of reinspection was May 7th, 2025. The result of that reinspection was non-compliance. Staff recommends non-compliance with compliance by next cutoff.
Noting the absence of the respondent, based upon our inspector's testimony and the photographs presented, I find the respondent in noncompliance and order the respondent to come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 3, Atlantic County 03 LLC. Anyone here for the respondent? Not seeing a respondent, what say the city?
Inspector Itani, Code Compliance, credentials are on file. This case was opened on November 22nd, 2024. A complaint generated case for unmaintained landscaping, outside storage, dirt and grime, no permit for the stairs, trash and debris, junk vehicle, damaged shed and garage, damaged exterior walls, no screens, no address numbers, damaged roof, damaged interior surfaces, interior trash and debris, plumbing issues, inoperable water heater, inoperable heater, inoperable appliances, inoperable electric, and no smoke detectors. First notice was received January 3rd, 2025. Compliance was due February 3rd, 2025. Last inspection was May 12th, 2025, and the result was non-compliance. There has been no contact with the owner. Staff recommends a finding of non-compliance with compliance due by next cutoff.
The city would also like to add that the respondent has been properly notified.
Noting the absence of the respondent based upon the inspector's testimony as well as the photographs presented, I find the respondent in noncompliance and order the respondent to come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 4, William Dennison Sr. Yes, gentlemen, if you would please state your names and be sworn.
William Dennison, Sr.
Wesley Amos. Amos, A-M-O-S.
Do you swear and confirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
I do.
Thank you.
Mr. Dennison, do you agree these violations existed or occurred as stated in the notice of violation?
The violations, Mr. Amos has been written for 9 years, and he's the property controller, so he takes care of that stuff. I think he's completed all the
I don't
repairs.
think they've been sworn in yet.
Pardon?
I don't
Yes.
think they've been sworn in.
Yes, I do.
Okay. Apologies if I missed it.
Well, at the time that this notice of violation was served, did they exist?
Yes.
Okay. I find the respondent in noncompliance. How much time should reasonably be required for the respondent to come into compliance?
I would say by next cutoff, there is the matter of a business tax receipt and a zoning violation for a business or nonprofit that's being run at the property that may take some additional time, but by next cutoff will suffice for a checkpoint for progress on that.
Okay. I sense that y'all are itching to tell me you've already done some of this stuff.
Yes, sir.
What have we, well, let me try it this way. What's left to do?
There's a couple of things. The Camaro right there, it's going to the paint shop. As you can see, it's been worked on. We're trying to get it in. I've actually got that sold, so I'm just trying to get it to the paint shop. The boat, that's a story in its own. I had somebody that stole the motor and the outdrive on it. It was to be fixed, and it never came back with my motor or stuff. So I have a boat there that I can get it off the property. It's not a big deal. The RV, it hasn't, as you can see, it sits back. I didn't know that it needed to be tagged. It's insured, but it's not tagged. That's an easy fix to get tagged. The Suburban there has a good tag on it. Everything that she's asked for has pretty much been taken care of. The debris has been picked up, fixed, so that's done. The compliance issue on the business, I'm not really sure 100% where to go with that.
What's the business?
It's been a social club. You remember I was here 9 years ago, and
What is the social club?
Minglers,
Pardon?
Minglers Social Club.
Okay.
We were here,
Mingler's Social Club.
yes, sir.
And does that then tie into whatever the zoning issue is?
Well, this is what the problem is. I came here before I ever rented that building, talked to Mr. Jeffries in the department, and there was no problem with it. They came in, did an inspection, all of a sudden there was a problem. They didn't like us. I don't know if you remember, Mr. Hartley was the one that I hired to come in and we talked.
Why didn't they like you?
Huh?
Why didn't they like you?
City's the city. There was one lady in the zoning
Can we
and
be
planning
more
manager.
specific than that?
Well, I can. I mean, she didn't like the things that happened in the building.
Okay. I think all right, gotcha.
And
All
we
right.
were told at that time, well, this is another thing I have. This July, y'all sent papers to us saying they were destroying all the paperwork from that lawsuit because they were trying to sue us to close us down. Well, that didn't happen.
Okay, well, let's get back.
Yeah, object irrelevant.
Okay, so are we in agreement there's a need for a business tax receipt?
We were told no.
You told no.
We were told no.
Okay. Are we, and again, I'm sorry, forgive me, I must be dense this morning. What is the zoning issue? Are
T2
social
is
clubs
what-
not allowed in that particular zoning district?
I don't. When I came here and talked to Mr. Jeffries in the historical department, is who I had to talk to. That's who they sent me to. He had no problem with us. They found out that we were a club, and the lady, the zoning and planning manager, is the one that had a problem with us. There was a big fight with that. The city attorney told my attorney, look, we're just going to let this go. Don't worry about anything. Just have them stay under the radar. Well, we've stayed under the radar. You haven't had any calls for us for service. We've been here 9 years and that caused a problem.
The city would like to just put on record that this is hearsay and I am not aware of this discussion, just for the record.
And I did include some supporting documentation in your binder. The hearing secretary included it that has the documentation of the previously denied business tax receipt and the notes from permits and licensing, as well as record of active advertising on the internet for that type of club that the license was denied for, the zoning. I included it just so you could see it. If you don't have it, I have a copy of it here.
Well, I have it.
Okay.
I guess what I'm not understanding is what is the nature of the violation that's being sought? What is the zoning violation?
That a social club, adult entertainment is not zoned for,
Who calls it
that
adult
building.
entertainment?
it's noted in the record details for the licensing. There's a note from April 29, 2016 saying, based on the information submitted, staff is unable to determine if the proposed establishment meets the definition of club or lounge.
Who
Please
decides
provide-
that?
I don't see the name on the note, but it's part of the business license record details.
Okay, well, let me back up again. All right, the city is asserting a zoning violation. I'm asking what the zoning violation is. So is a social club prohibited at that location?
It says, note 51016, the proposed business is one or more of the following uses: bottle club, adult theater, or nightclub. Bottle clubs are prohibited in the city of Daytona. Adult theaters and nightclubs are not permitted uses in this T2 zoning district.
Who says, is it a bottle club?
No, sir, we are.
Hang on, just
Yes.
answer my question.
Yes.
I'm going to move this a lot faster.
Okay.
Okay, so he says it's not a bottle club, adult entertainment. Okay, well, I guess what I'm asking is, he says he's a social club. I don't care what anybody does at their social clubs. I don't know where these other labels are coming from, but I assume they have something to do with the city citing them for a zoning violation.
There's a previous case on the property where there's a lien fine for that. And so it's
A lien fine for what?
for that same violation at that property from the previous case.
And all
Did
that
I
was-
previously find
Yes, sir.
that they were in violation?
Yes, sir.
And what did I decide they were in violation of?
The zoning violation for that establishment. And them continuing to advertise it as such. And that's why I included the documentation of the advertisements that are still ongoing.
We are not for profit.
Okay, save your breath.
Yes, sir.
All right, we're going to continue this matter to our June 10, 2025 meeting. And I apologize, I have not gone through all this stuff, and I intend to do that. Club, I don't have a problem with it. I don't know who's calling it adult entertainment, but I obviously have to refresh my understanding as to what the rules are that come into play. And I guess this ties back into whether there's a BTR required.
Yes, sir.
So those two issues, at least, I'm postponing any decision until the June 10, 2025 meeting.
Okay.
Everything else is to be brought into compliance.
Yes, sir.
All right? Are you proposing it be in compliance by June 4th?
Yes.
What say you to that?
Yes, sir, no problem.
Okay. So, with regard to now, and I want to make sure I'm not short shrifting anybody. I want to take a look at the zoning violation aspect. I want to look at the no BTR aspect. Is there anything else in this list of violations that would fall under those two topics?
No.
Okay. Then those two items, I'm deferring for any decision until our June 10, 2025 meeting. I'm not making a finding of compliance or non-compliance. I'm not imposing a cutoff date to come into compliance on those two matters. With regard to the balance of the notice of violation, the respondents to be in compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Now, for the city's benefit, is there anything more that you think I ought to be looking at between now and June 10th? Well, let me put it this way. If there's anything more you want me to look at between now and June 10th, I'll look at it. If there's anything more you want me to look at between now and June 10th, get it to the city attorney, and the city attorney will get it to me.
Now, she's changed because the other city attorney dealt with it back in,
I can give you a business card. I'll have my
16,
paralegal bring
no.
one down.
okay. There's the one that dealt with it back in 2016. All this was squashed. From what I was told, the city attorney went through you and it was done.
Okay, I apologize.
problem.
I now remember who you are and what you do. All right, whatever. I don't remember the outcome. I don't remember if it was decided here or somewhere else. Sorry, Alzheimer's.
No problem. Well, like I said, it'll come out to where
All right.
we're
So
in compliance.
we'll hear that aspect on June 10th.
Yes, sir.
All right, good luck to you.
I just texted her. I can also write it down for you.
Okay.
Sorry, I don't.
All right, case 5, we've already addressed. Case 6, Daytona Beach MHP LLC. Is there anyone here for the response?
sir.
Good morning. You would state your name, please?
Yes, sir. My name is Sean Cornell. I'm an attorney that represents the respondent, Daytona Beach MHP LLC. Beside me, I have Miss Dion Cuchel, who's the property manager for the mobile home park.
If you think she'll be testifying, she needs to be sworn. You do not.
Yes, sir.
Ma'am, could you state your last name?
Kuchel,
Spell it.
Kucel.
Raise your hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
So help me God, I do.
Thank you.
Real quick, administrative matter. Is this my copy?
Yes.
Okay.
And sir, I do have an additional copy of some exhibits for Your Honor as well.
Sure.
And I did also bring Mr. Tom, the court reporter here, just to keep a record of the proceeding. If the city's planning on introducing exhibits, do you have any hard copies that would be able to retain for the record and be distributed?
They're all photographs and, well,
Okay.
All right, anyway. As to the respondent, are we in agreement this violation existed or occurred as stated in the notice of violation?
No, sir.
All right. Then let's go to our inspector first. And as to the matter of noncompliance, what say the city?
Good morning, John Stinson, Code Inspector with the city. All cases are on file. Okay, this case began as a police complaint. There were issues on the property with living in the shed. There was outside storage, rodent harborage, damaged fencing, junk vehicles, damaged exterior walls, windows, roofing, and wiring. Since then, the shed has been completely removed. Outside storage of junk and debris is...
Is that the shed?
No, that's the shed's behind that.
Okay,
That's the shed to your left of the screen.
all right.
The shed has been completely removed. The majority of the outside storage of junk and debris has been removed. There's still the issue of fencing and wiring on this property. This is an ongoing issue. Obviously, it's a trailer park. As of right now, the only thing we're dealing with now is the common areas, the outside storage. The shed has been removed. The fencing is still in non-compliance and needs to be repaired. Let's see.
Where's this
Oh,
trailer
well-
park?
It is on 622 North Beach Street. That is south of Madison, but north of Riverview? Fairview.
I'd like to clarify
I'd like to,
that.
do you mind if I just quickly mention
Sure.
this before? So just to back up what Mr. Stenson here said. So for the record, this packet with exhibits, the city has, myself, the city attorney, has received this today. So I haven't had a chance to really read this in depth, but upon a skim, it looks like the argument they're making is under Florida statute 723.024, which states that a lien, penalty, fine, or other administrative or civil proceedings may not be brought against the mobile home park owner or mobile home park property for any, and this is where I want to emphasize, for any duty or responsibility of the mobile home owner under the statute. We are not here alleging that the mobile home owner is responsible for this, because these are common areas. So this argument, again, from what I skimmed, because I only received this now, isn't pertinent to this case.
I completely and respectfully disagree with that assessment. Number one,
Folks, time out. Let this guy finish.
okay.
You.
Last thing. This also does not include a contract between the mobile park property and the mobile home owner that clarifies what is the responsibility of each party, but it is clear that the common areas would be the responsibility of the mobile park owner. That's all I have, sorry.
That's fine. That's all I have, Mr. Felger. It's the common areas, the outside storage, and the fencing.
Between Madison and Fairview.
Now, mind you, you're on Beach Street now.
Oh, so is this some remnant of that big?
There were
old-
3 different trailer park properties there. 2 of them
Okay.
are gone.
There we go.
This is the one that's left, that's in the
So
middle.
this is what you can still see when you look in the distance as you drive around that area.
That's correct. This photograph was taken yesterday, sir.
Okay.
The circles represent the fencing, the outside storage, and the wiring that was left.
And Daytona Beach MHP LLC is what, the owner of the park?
They are the owner of, for lack of a better description, the ground.
Okay, well, I suspect that means the park and the common elements.
Yes, sir.
The real estate.
Okay, all right. And I've seen lots of photographic evidence of outside storage, unmaintained property, yada, yada, yada. So, what say the respondent?
Well, sir, I'll start with my client here is the owner of the mobile home park, and so they own, as Inspector Stinson alluded to, they own the land underneath the park, they own the common areas, they own one building at the entrance to the mobile home park. Now, there are 32 individual mobile home lots in the mobile home park. Each one of those lots is leased to a mobile home owner. The mobile home owner is a separate individual. My client is a business, but most of them are residential individuals. They own the mobile home on the lot, and they maintain the lot itself, which is the space immediately surrounding the lot, or immediately surrounding the home. Now, Chapter 723 of the Florida statutes is the Florida Mobile Home Act. My law firm is very specialized, and that's about all we practice, and so I help my client with landlord-tenant issues within the mobile home park space. There is a statute that preempts a local government from assessing fines, liens, violations of this nature against the mobile home park owner. That statute 723.024 states that the local government, when they want to issue a fine in a mobile home park, they need to issue that fine, and they needed to address the issue with the mobile home owner, himself or herself. Now, that's not to say my client has a concurrent interest with the city here. They want to make sure that their property is well maintained. The property manager beside me, Dion, certainly has the same interest in mind in trying to get her residents to clean up their property, and has done a lot since these original photographs were taken to ensure that the issues at this lot number 180, were addressed. But from a procedural perspective and from a legal perspective, this case should not be brought against the mobile home park owner. It should be brought against the mobile home owner, who is an individual by the name of Tanya Test, and we know exactly who it is. And when this case originated after the first notice was sent from the city, February 20th, we immediately had a conversation with Mr. Stenson. Officer Connolly was on that Zoom call as well. We had a Zoom call with myself on the call, as well as the property managers, where I sent this letter that I provided to Your Honor and to the city attorney, which states, we understand your interest here. We understand that you want lot number 180 to be cleaned up, but all of the issues in the initial notice are addressed to lot number 180, and the notice itself is addressed to lot number 180. It's not addressed to the common areas of the mobile home park. It's not addressed to the one building that's located on the park. The notice itself is addressed to lot number 180. And we had a conversation. We said, hey, we understand that you want us to clean up, that you want the tenant to clean up lot number 180, but you need to address this with the tenant, with Miss Tanya Test. She's the mobile home park owner, or she's the mobile home owner, not the park owner. And after that conversation, I thought we were in agreement that that's what the city was going to do. They were going to take this case properly, and they were going to address the issue with the mobile home owner. And then the next piece of paper that we received was the notice that scheduled this for a hearing today. So from a legal perspective, there's a lot of argument to say you're suing, or the city is coming after the wrong defendant. Now, when we actually talk about the facts and the issues, what my client will tell you is she's done a lot of work with this resident, working hand in hand with this resident to clean up this mobile home lot. Essentially, and I'm specifically addressing lot number 180, there was a subtenant living in the mobile home owner's home. That subtenant was evicted from the home, and then the mobile home owner, Miss Tanya Test, took back possession of the mobile home. And in the meantime, what our position is and what Ms. Test's position likely would be is that of those 12 initial violations that were outstanding, most of them have been cured, including the shed was demolished, the fence was fixed, all of the junk and debris was removed from the lot, and the improper wiring was removed from the lot as well. And I have evidence and photographs to present about all those issues. And essentially, my client's position, unfortunately, is a little bit adverse to the position of Ms. Test. The only remaining 5 violations that we can state probably remain are Ms. Test's responsibility under that Florida statute to cure and fix herself, and it's up to the city to deal with that issue with Ms. Test. So my position, if you'd like me to get evidentiary and present some of the photographs I have, I'd be happy to do so. But my position is that this violation against the mobile home park should be withdrawn.
So we're speaking about evidence here. The big piece of evidence that we need that is not included in this packet, at least from what I was able to skim, is the lease agreement that states she's responsible for these areas. Because it appears to Mr. Stenson that these are common areas not within Lot 80. And number
Sure.
2, the notice of violation is addressed to the property owner, your client. So I'm not sure where you're saying that it's addressed to Lot 180, is that what you said?
Sure.
But
Well,
there's nothing in here that shows and proves that this is not a common area.
well, there is the statute immediately
The
preceding.
statute's not evidence.
No, I'm sorry. So the statute, you're asking for an agreement that states what says that the mobile home owner is responsible for maintaining the mobile home and the mobile home lot. Well, the statute preceding 024 is 023, and it states the mobile home owner is responsible for maintaining the mobile home and the mobile home lot. Now, my client can test.
We're not citing the lot, though. We're citing common areas.
No, I think you're misinterpreting what a mobile home lot is, because under their lease agreement, and I can have my client testify
Yes,
about.
I would like to see the lease
Sure.
agreement because we don't have that.
Sure, and so I can have her testify as to whether there's an oral agreement or a written agreement. I can also have her testify.
But without the lease, her testimony is hearsay.
If it's an oral lease, which is statutorily recognized under Chapter
Okay.
723, then it would
You
be
have an oral
recognized.
lease, but
Yeah.
Well, for the record, our attorney is correct. We did have a meeting with Stenson and his supervisor, Mr. Denzel, along with Sergeant Conley, and we did talk about this. He keeps stating that it's common area. That entire lot that you saw around there, that is the lot 180. The common area is the driveway, is the road. That is the common area. So I have, Your Honor, these pictures of the shed prior, and there is wiring from the shed all the way over there. That is what we were told. The picture that you see on there with a plug in there, that is coming from another unit from across the way, which is lot 181. That is their plug. That was not there. I have all the pictures here. Also, as far as the fence goes, they said on that paper about the structure which is the shed. As you saw in those pictures, the shed was leaning up against the fence. The fence has actually been fixed. We paid over $144 at Home Depot. Oh, my maintenance tech, which is
Your
John.
maintenance tech, who works for who?
Who works for us?
Who is us?
Oh, Daytona Beach Mobile Home Park.
The owner of the property.
Owner of the property, correct. We weren't sure who put that fence in or anything like that because we purchased the property many years ago. So I had asked Sergeant Connolly in a text to
Okay,
who's the
I've
back.
heard enough of this. For starters, how are we supposed to know where the lot stops and the lot starts?
Well, he never asked us that.
Pardon?
He never asked us that.
Well, you're the one coming in here claiming that the mobile home owner's lot is the mobile home owner's problem.
Sir,
It's
well,
not what they want
it-
us
Just
to
a
do.
it's-
second,
for it.
and don't interrupt me again.
Sure.
You're the one coming in here saying the mobile home owner's lot is the mobile home owner's problem. I'm seeing garbage and trash all over the place. I can't tell from looking at these photographs where the unit owner's lot starts and where it stops. For all I know, it may spill into common areas, and if that's the case, you're properly here.
Right.
You may be properly here anyway because there are lots of tenants that are dragged in here. I'm sorry, there are lots of owners that are dragged in here because their tenants aren't maintaining the property. So, now, before we get too much deeper into the weeds, and you're also telling me some of this work has been done.
I actually took care of it because it was under eviction, which Stenson was aware of that.
Okay.
They were under eviction through Atlas Law, and we had an agreement, which I believe she has as well in there, in that packet, as well as Your Honor does. And once that was evicted, which I believe was the 17th or 18th of April, the very next day, I had a common company called the Juggers come in and trash out everything on the outside of the area. I have pictures of it, along with the sheriff that's in the photo that served the
Okay, I'll
summons.
take your word for it.
I do have them if you'd like to see them, Your Honor.
That's fine. Now, as far as culpability here, which to me is not an insignificant issue, we're going to continue this matter to our June 10, 2025 meeting. If you're going to argue that the boundaries of your responsibility are outside the unit owner's lot, then show me something that gives me an idea as where that lot stops and ends.
Gotcha.
Then, hopefully, I'll hear from Mr. Stenson here that the majority of the issue of the problems have been taken care of, and whatever remains to be dealt with, you know, if it's over here, maybe it's your problem. If it's over there, maybe it's their problem. If you convince my attorney down here, who I get my advice from, that somehow I'm prohibited or precluded from holding the mobile home park owner responsible. So, it sounds like at the next meeting, we need to, if there's any need for this at all, because quite frankly, if it's brought into compliance by the time we meet, the response may be it's in compliance. And so, Mr. Magistrate, you don't have to make any draconian decisions here. If that's the case, fine. If we're going to continue down this road, I need to see the lease. I need to see this. I'm not going to make you go get a survey. Bring me whatever you have that shows me where the lot lines stop and start. 10-4? So it sounds as though some remedial work has been done. I'm taking this lady at her word. And counselor probably wants to protect his client's interest before anybody goes making any determinations that the park owner has been held in non-compliance. And if these two are going to be getting into that, then I'll hear that. And what I'm primarily interested in is that this is cleaned up and taken care of ASAP.
Yes, it has.
I will let you know, I'm not going to admit to any prejudice or bias, but we have many a property owner brought in here and held liable for violations caused by their tenants. I'm just stating that as a general matter of fact. That's not to say I'm not going to listen to what everybody has to say as to why it ought to be different here. Okay? We all good?
Yes, sir.
Everybody know what we're looking for when we meet again, if necessary?
Yes, sir.
Very good. Good luck to y'all. Case number 7, PBNDCC LLC. Anyone here for the respondent?
Good morning.
Morning.
My name's Andy Bonus. I am here to just provide status update on case 7.
Say your last name again?
Bonus, B-O-N-U-S. Mr. Stenson?
Okay. Mr. Bonus, what is your affiliation with this limited liability company?
None whatsoever.
Well, that's not the answer I've got to hear. Tell me you're a manager. Tell me you're an authorized agent. Tell me you're an owner.
I am a manager.
Tell me you're best friends with the guy's dog or something.
I was asked to come and represent them. I am the project manager for these things that are
sounds
happening.
a lot better.
Okay.
Raise your right hand,
Sounds a lot
sir.
better.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Yes, sir. Mr. Bonus, do you agree these violations existed or occurred as stated in the notice of violation?
I do.
I find the respondent in noncompliance. Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance?
They should be able to come in compliance by next month.
Okay, Mr. Bonus, the city seems to think you ought to be able to take care of this stuff by June 4, 2025. What say you to that?
I'd feel pretty good about that. We've 200 feet of that fence that has been an eyesore out there forever has already been replaced, so they're working on it. They should have the fence done by the end of this week, so you'll never have to look at that ever again.
Okay.
And the sanitation in the pool, we've cleaned and drained and cleaned the pool. The problem with the pool right now is it's 130,000 gallons, and we have one pump and one motor. The other pump and motor, there's no electricity. Giles Electric is supposed to be there today to start looking at that. So yeah, we're working on all this stuff and
All right, well, if you get in a
do
bind,
our best we can. Yeah,
if you get in a bind, you'll like talking to this gentleman.
I
All
think
right,
you
I'm going to order the respondent to be in compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Thank you, sir. Thanks, appreciate it.
Case number 8, Aria International Realty, LLC.
Hello.
Good morning.
My name's Elisa Cooper. I'm the property manager.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right, Ms. Cooper, do you agree these violations existed or occurred as stated in the notice of violation?
Yes.
All right, I find the respondent in noncompliance. Mr. Stenson, how much time should reasonably be required for the respondent to come into compliance?
This property should be able to come in compliance by the July cutoff.
That would be July 2, 2025?
Yes, sir.
Awesome. That's what I was going to ask for too, because the stucco is the stucco, and we found a wall that has to come down.
All right, Ms. Cooper, what say you to that?
That sounds good.
Pardon?
We should be able to come in compliance by July 2nd, you said?
Yes, ma'am.
Yes.
Very good. I'll order the respondent to come into compliance by July 2, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. You've got a healthy laundry list of things to do here.
Oh, yes.
You get in a bind, stay in touch with this gentleman, let him know what's going on.
Awesome. Awesome.
And that will help you in the long run. Good luck to you.
In case you can't make it by the date, the hearing date is the 8th. The 7th is just the cutoff. I mean, the 2nd is the cutoff date. The 8th is the
The
hearing.
8th is the hearing?
Yes.
Okay. Awesome. Thank you. So I have your email. Awesome. Yeah, we have like 30,000 in stucco that we're doing. So.
A lot of work.
Have a great rest of your day.
Thank you.
Good luck. Case number 9, Quest IRA Incorporated for benefit of Stephen Matthew Hahn, IRA. Anyone here for the respondent?
We have Zoom representatives, Your Honor.
Okay.
Good morning, Your Honor. Leanne Wagner, counsel for Respondent Halifax Shores Homeowners Association.
Morning, Your Honor. Ed Fanning on behalf of the Halifax Shores Homeowners Association.
I didn't hear his name. Can you say your name again, sir?
Sure, Attorney, or Ed Fanning, Fanning, and I'm the president on the board for the HOA for Halifax Shores.
I need to swear him. Did you say you were an attorney or no?
Well, I am an attorney, but not licensed in Florida, so I don't want to represent as an attorney for Florida. That's why we have Leanne.
Okay. You want to raise your right hand? Do you swear and affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Counselor, your last name again, please?
Wagner, Wagner.
All right. Ms. Wagner, are we in agreement these violations existed or occurred as stated in the notice of violation?
We do. However, I think it's important to bring to your attention, Your Honor, that there was a meeting between Mr. Fanning, another member of the board, and Mr. Morris, James Morris, and Denzel Sykes in mid-January, where there was some discussion as to whether and how certain portions of the work had to be performed. I believe there was perhaps a miscommunication as to who was waiting for what information. As of last week, Mr. Fanning has been in touch again with Mr. Morris, and I believe there are just a few items of information that need to be provided for the association to determine how it can perform the work. The items in question are, given the age of this building and the fact that the pavement has been there for approximately 50 years without issue, is it possible to leave the dumpster where it is without ripping up the parking lot and installing a 10 by 20 concrete slab? Question 2 is, if we have to install an enclosure around the dumpster, which we believe we may, can we do it without doors? Because I think someone from the city had made a comment that actually promotes perhaps occupancy by the homeless who are looking for a secure place to stay. And the third question is this association possibly grandfathered in, given the age of the building, it's approximately 50 years old, to where we would not need to build an enclosure around the dumpster? So those questions have again been represented to the city. We're waiting to hear back, and Mr. Fanning is here to speak to that as well.
So right now, the notice of violation is an unenclosed trash dumpster, and I take it is still an unenclosed trash dumpster.
It is, sir, yes.
Okay.
And
Then
again,
I find the respondent in non-compliance. Hang on, I'll come back to you in a second. How much time should reasonably be required for the respondent to come into compliance?
By the next cutoff.
The inspector is suggesting you ought to be able to have this rectified by June 4 of 2025. Now, what say you to that? And now is the time for you to talk about all your extenuating circumstances that you've alluded to already. So, I guess what I'm saying is you've got between now and June 4 of 2025 to have higher authorities, so to speak, intervene and clarify what needs to be done, or failing that, come into compliance. And coming into compliance means you are free to ask the building department what you're required to do and what you're not required to do. And if you take issue with that, you're free to bring it all right back here to me for me to decide. So I guess what I'm saying is you've got till June 4th to come into compliance, and now is the time for you, I guess, to pursue this panoply of explanations you have as far as how you're to proceed.
thank you, sir. So
I don't know if that provides you any clarification at all.
It does, but I again, as my association has been waiting since January to get answers to these questions, I don't know that we will have a response by June 4th. Mr. Fanning, I believe, indicated that Mr. Morris back in January asked for 90 days to research, and Halifax Shores has not yet received the necessary information. So we can certainly, if we don't have the information, come back to you next month and advise you accordingly. But I would hope that you would consider that when determining whether or not to impose a fine.
Well, I most certainly will.
Thank you.
Now, ultimately, we're going to get an answer to this, and ultimately, we're going to find out what has to be done, and ultimately, it will get done. And as long as I'm satisfied that there's a good faith effort on y'all's part to get the matter resolved, I'm not an unreasonable person. So that having been said, go explore and do whatever you need to do. Hang on a second.
Your Honor, yes, sorry, I didn't want to interrupt.
You need to move this thing. Is
Yeah,
that
I
someone's
can.
name?
Let me move it.
That's okay. I don't want to create. Never mind.
Here, I'll move this way. Thank you, Your Honor. We just wanted to add that these questions have already been answered, but we would more than happily send them an email just to put it in writing for the record shortly.
Thank you, Ms.
That
Dan.
would be great, because I have not received the answers. The second though, just for a point of order though, Your Honor, because I don't want a ruling that would be inappropriate. Quest IRA Incorporated, FBO Stephen Hahn IRA, that is the wrong party. I don't, and so I don't want a ruling that would affect this individual whom I have no association with, no authority to present. So I don't know if the city needs to amend their notice and get the proper parties on there, but I do not know Quest IRA Incorporated. I'm the president of the Halifax Shores HOA, which is the owner of the common areas of 405 North Halifax Avenue. And I would not want a ruling against Quest IRA or represent or think this court that I have any authority for Quest IRA Incorporated.
All right, well, they're all here listening to you. So be sure to bring it up again if need be.
So, if I would...
Hang on.
I would just like to add the reason that it's listed that way is because the property appraiser's report has them listed as the owner in fee simple 100%.
Apparently, we're getting this from the property appraiser's office.
Per the statute, we have to cite the way the property appraisers has it. So if there's a mistake, they need to correct it with the property appraisers.
We've gone in and corrected it. It appears that perhaps at some point in time, a prior board member changed it inadvertently. We have requested that it be updated to Mr. Fanning's mailing address so that the president will receive the notices.
Thank you for letting us know. Do you mind letting us know when it's been corrected with the property appraiser's report and we'll make that edit? I just can't do it until it's been corrected. Thank you.
Sure. I'll be happy to email it to you. Thank you.
And once those issues are squared away, we'll substitute the proper party, assuming that's what we need to do.
Okay.
Thank you.
All right, folks, good luck.
Thank you very much. And thank you, Inspector Stenson.
Yes.
Case number 10 is in compliance. Case number 11, Christopher R. and Joy Loudon. Anyone here for the respondent? Respondents. What say the city?
Okay, good morning, Sarah Kirk, Inspector with the city. My credentials are on file. This is a complaint-generated case that I received in July of 2024 for work being done without permit. Property is in violation of work without permit, structural and electrical, rotted wood, broken boarded windows, peeling paint, and inadequate address numbers. First notification was July 31st of 24. Compliance due 8/31/24. I visited the property on Friday, May, what was it? May 9th. Non-compliance, staff's recommending a finding of non-compliance with compliance due next cutoff.
The respondents have been properly notified.
Based upon the, noting the absence of the respondent, based upon our inspector's testimony, I find the respondent in non-compliance, or the respondent come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 12, Ivan and Carden, LLC. Anyone here for the respondent? Yes, sir. Yes, sir.
Good morning, my owner.
If you would please state your name.
My name is Charlie Nguyen.
And what is your affiliation with Ivan and Carden LLC?
I'm the owner.
All right. If you would please be sworn by our secretary.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right, and I'm sorry, your last name again?
Nguyen, Nguyen.
All right, Mr. Lin, do you agree these violations existed or occurred as stated in the notice of violation?
Yes.
All right, I find the respondent in non-compliance. Mr. Inspector, how much time should reasonably be required for the respondent to come into compliance?
Next cutoff.
The city seems to think you ought to have these matters taken care of by June 4th, 2025. What say you to that?
Yes, we already in the agreement with the fan company. So they already scheduled to get it done by the end of next week. I have one of my concern is my front door glasses, which was broken by the Daytona police. So we were still. I mean, I don't really know who should be. Of course, that's my building, so that's my property. But then the Daytona Beach has broken the glasses to arrest a tenant. So is that are we gonna replace it or without cost, or the Daytona Beach gonna help us with that?
Well, I'm looking to you to get it fixed. Who you collect or who you collect it from or get reimbursed from is your business.
Because the tenant has been evicted out since they do illegal activity there. So there's nobody is no resource for me to collect it back. So it's probably out of my pocket right now.
All right. Where are you located?
I am located in Texas, Dallas, Texas. So we're gonna do is our plan. We're gonna do the fan gonna be replacement by the end of next week, and the front door glass. I already scheduled the company to come in to take a look at it. Probably do the estimate today. So and we plan to put the camera, the surveillance camera there, so to make sure all the debris and trash and everything gets taken care of in the future.
Okay. So you're going to have it done by June 4, 2025?
I mean, if we can have more time, would be the best, but
I'll give you to July 2nd, except you won't be allowed to use it until it's in compliance.
You mean not allowed to use it, like the business cannot operate there right now?
Right, not until the building's in compliance.
Then I would try to get it done by the next
right.
hearing.
And I'll order the respondent to be in compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Your Honor,
Thank you, sir.
I would like to remind you, he also has miscellaneous business for lien review. I didn't know if you wanted to hear that now or continue in order and do that at the end. Yeah. Oh.
Okay, is this lien review been amicably resolved? Or is this a contested matter?
On the miscellaneous business, Anthony Jackson, attorney for the city. Yeah, this has been amicably resolved.
If it's been amicably resolved, I'll hear it now. If it has not been amicably resolved, I'm not making these people wait for the last matter on the agenda.
Yeah. No, sir, this is something with the council, Mr. Lambert, and I have a agreement as to this
Okay,
resolution.
all right. We're also going to address your lien review, and let the city attorney explain what the resolution is.
Yes, sir.
You have a lien review request. Is that correct?
No, I don't think so. I'm not aware of that.
Okay, just clarification. Nothing. We have nothing against or regarding Ivan Carden. Our request is really specific to Social Daytona Inc. The order will remain as previously written as relates to Ivan Carden. So I didn't realize he was here on behalf of Carden, since we frequently had a woman and a different attorney.
So we're done with this gentleman?
Yeah, we would not need this gentleman.
Okay, thank you, Mr. Lynn. We're done with you. Be in compliance by June 4, 2025. Make sure you stay in touch with your inspector regarding your progress.
Thanks, my owner.
Good luck. All right, we're here anyway. What's the...
Yes, Ms. McKelvey, this case is one of several cases we had with this pair. specifically relating to Social Daytona. This is the business that was there on 631 North Grandview that was doing the selling
Alcohol flavored water?
Right, exactly.
Gotcha.
And ultimately on that case that had they raised that issue, there was a determination, a finding by the magistrate and an ultimate ruling, and they were fined $15,000 fine. They were the only ones fined. Carden was not fined in that case. So the only ones fined was Social Daytona. And subsequent to that, Social Daytona filed an appeal. We also had an additional order from the case preceding that was also imposed a $15,000 fine, and we had a case that was after that imposed $30,000 as it related to Social Daytona. So the ultimate decision that was made in between the parties was the appeal that was issued as related specifically to this case was an appeal because of the issue of the spoliation issue that ultimately went to the criminal court as well and was dismissed. And so we agreed that we would ask to vacate this order and they would dismiss the appeal just from a legal and financial economy. It was not something that was going to be of any specific benefit to the city nor really change the circumstance as related to Social Daytona. They are out of the building. These fines that we do have imposed will remain, and the only one that would be changed is this one case, which would be removing the $15,000 fine. So what we're asking is to vacate the order imposing the fine. So
slow down, Kemosabe.
Yes, sir.
So the city came here and asked me to fine these people $15,000. Is that right?
That's correct.
And I fined the people $15,000.
Yes, you did.
Now I'm starting to feel like I'm out in Siberia and I don't have a winter coat. So now we're folding on the $15,000 fine that I imposed that the city asked for?
Mr. Magistrate, I want to remind you that in this situation, the Social Daytona were mere tenants. So the effect of the fine would be seeking judgments against temporary property ownership against an LLC. We would continue to hold $45,000 fine liens against anything they own.
Okay, well,
this case would only be a slight change from the total circumstance.
I guess what I'm probably more interested in, okay, are you allowed to talk about this right now, or is there litigation pending still?
There is nothing pending other than the appeal as it relates specifically to this case.
So the appeal is pending?
Yes.
Still?
Yes. And
So the dismissal of that appeal is part of this?
Yes.
All right, well, then I'm not going to ask any more questions. Okay, since we don't know what the outcome of that is. So in any event, the relief the city now wants is for me to vacate that fine.
Yes, and again...
And you're asking me to vacate that fine because you and the parties have gotten together and amicably resolved ongoing litigation subsequent to this order for strategic purposes.
That's correct.
Let's leave it at that.
Yes, sir.
That sound accurate enough?
That's accurate enough, yes.
Okay. All right. With regard to SMG 042480, as to the respondent Social Daytona Incorporated, not to include the others that are listed.
That's correct.
I am vacating the previous order imposing fine and lien effective April 12, 2024 in the amount of $15,000. And am I waiving the recording fee and interest as well?
Yes, sir.
And I'm waiving the recording fee and interest as well. Does that take care of it?
That takes care of it.
Very good.
Thank
Okay.
you.
Good to see you.
Same here.
Okay, I think we're up to case 14 now. Alice M. Younger. Anyone here for the respondent? Not seeing a respondent. What say the city?
Good morning, Inspector Bostwick, City of Daytona Beach, credentials on file. This case was a citizen's complaint opened on February 27th of 2025, an unmaintained vacant lot with trash and debris. First notification was on March 6th of 2025. Property was posted. Compliance was due by March 17th of 2025. Last day of reinspection was May the 9th. Result non-compliance. There's been no contact with the owner. Staff requests a finding of non-compliance with compliance due next cutoff.
And the respondent has been properly notified.
Okay, noting the absence of the respondent based upon our inspector's testimony as well as the photographs presented, I find the respondent in non-compliance and order the respondent to come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 15, Marion White Edwards and Shondaria Cunningham. Is there anyone here for the respondent?
The respondent has been properly notified.
Not seeing a respondent, what say the city?
All right, case was also a citizen's complaint opened on March the 13th of 2025, unmaintained vacant lot with trash and debris. First notification was on March 19th. The property was posted. Compliance was due by March 31st. Last day of reinspection was May 8th. Result non-compliance. There's been no contact with the property owner. Staff requests a finding of non-compliance with compliance due next cutoff.
Noting the absence of the respondent based upon our inspector's testimony as well as the photographs presented, I find the respondent in non-compliance and order the respondent to come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 18, Plinio A. Sepulveda Torres. Is there anyone here for the respondent? Not seeing a respondent, what say the city?
Our respondent was first notified on January 24th of 2025. Since last month's hearing, there's been no contact or progress. Staff requests a fine of $250 a day with a max fine of $15,000.
The respondent has been properly notified.
Noting the absence of the respondent based upon our inspector's testimony, the photographs presented, I'm fining the respondent the sum of $250 per day commencing May 8, 2025, and that fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property is brought into compliance. Case number 19, Pay Land Trust dated March 16, 2010. Anyone here for the respondent?
The respondent has been properly notified.
Not seeing a respondent, what say the city?
Our respondent was notified on January 27th of 2025. Since last month's hearing, there's been no contact or progress. Staff requests a fine of $250 a day with a max fine of $15,000.
Noting the absence of the respondent based upon our inspector's testimony as well as the photographs presented, I'm fining the respondent the sum of $250 per day commencing May 8, 2025, and that fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property is brought into compliance. Case number 20, Cerberus Investments, LLC. Is there anyone here for the respondent?
The respondent has been properly notified.
What say the city?
All right, the respondent was notified on February 14th of 2025. Since last month's hearing, there's been no contact or progress. Staff requests a fine of $250 a day with a max fine of $15,000.
Noting the absence of the respondent based upon our inspector's testimony as well as the photographs presented, I'm fining the respondent the sum of $250 per day commencing May 8, 2025. That fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property is brought into compliance. Case number 21, EM Realty of Florida, LLC. Is there anyone here for the respondent? Not seeing a respondent, what say the city?
Good morning, John Stinson, Code Inspector with the City. Qualifications are on file. All right, this respondent was first notified on 21 September 2024. They were decided for dilapidated parking lot, peeling paint, failing stucco on exterior walls, dilapidated exterior doors, exposed wiring on the exterior of the structure. Excuse me. There has been a permit that was issued on 16 March of this year. However, there has been no progress made other than the permit being applied for and issued. The city is asking for the imposition of a fine of $200 a day to be capped at $15,000.
Did you say 200?
200 per day.
Noting the absence of the respondent,
They have been properly notified.
based upon our inspector's testimony as well as the photographs presented, I'm finding the respondent the sum of $200 per day commencing March 6, 2025, and the fine will continue to accrue each day thereafter until the fine has reached the sum of $15,000 or the property is brought into compliance. Case number 22, Sunshine Ventures and Management, LLC. Is there anyone here for the respondent?
Yes, Your Honor. Dennis Baer, counsel for the respondent. And I have a client rep. His name is Kobe Betzalel. Last name is Betzalel.
All right. I have that this matter was continued from the April hearing for a progress report on a permit and to set a compliance date. Mr. Baer, are you going to provide me, first off, is your client going to be testifying?
Yes, sir. I request he be sworn in.
All right.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
All right. Will one of you please give us a progress report?
Judge, I'll give you the review of the permit status, and Mr. Betzalel can tell you about some more recent developments. But in reviewing the permit file, the permits were applied for on April the 9th, 2025. We just got a report back. Basically, the construction plans, the energy calculations, and the site plan are complete. We just need to do a follow-up asbestos study before they will issue the permit. It shows that we're going to be spending about $567,000 in improvements for both the exterior and the interior of the building. The contractor is Siemens Construction. He could not be here today. He's on a site inspection on another project. And Mr. Betzalel will fill you in on the windows, which are the next big part of the project. But we have retained a window contractor, and Mr. Betzalel can fill you in on the rest.
Yes. So as far as the permit, as I understand from the GC, we're now being asked to do the asbestos report. So he's working on that to get that filed in as well. And as for the windows, we're already in discussions with a Windows vendor that's supposed to come next week to start doing the measurements. And once we have all the measurements and everything is set up, we can put we can put the order in. As we understood from the vendor, as far as ETA for delivery should take between 5 to 8 weeks due to this is a really large order, and also this should be hurricane-proof windows, and that's why it takes more time.
Mr. Betzalel, have you been paying somebody to maintain the exterior of the property as far as the maintenance of the grounds?
Yes, everything been taken care of as far as the landscaping and all that stuff, yeah.
And how about the fence?
That as well.
Okay, let's hear from the city.
Your Honor, I have a question, if I may. Apologies if I missed it, but I just wanted to confirm, you have hired a contractor?
Yes.
Do you recall roundabout when that was?
Well, the permitting file shows that the permit was issued on April the 9th. It was applied for on April.
I'm just asking, do you know when your client hired a contractor?
Kobe, how long has Tom Siemens been working with you?
So you're the contractor.
Specifically no, I'm not the contractor. I'm the owner. The contractor was hired, I think back in March or something like that.
The only reason I ask is just because I believe this is the permit note. It says that there wasn't a contractor listed, and on the April 7th, they asked for more information. Did you provide that additional information with the contractor's information?
It was provided. Yep, it was
You did?
provided.
Okay. I know, I apologize. I'm not with licensing, so I'm not sure. Just this is for an update. Have you given them the asbestos survey? Apologies if I can't pronounce it. The survey. Have you provided the survey to licensing?
Again, what we've been asked to provide is the asbestos report.
Okay.
And that's the only thing that is missing as far as I'm understanding for the completion of the submission of the permit.
Okay. Thank you for providing that additional information, Mr. Stenson.
Okay, Mr. Inspector, where do we stand?
This particular property itself has been an issue in the city for quite some time.
You don't have to give me the history. I drive by it twice a day.
There you have it. In this particular case, we are focused on the landscaping, the boarding windows, doors, being in this particular state for over 120 days, along with dilapidated fencing and peeling paint. Peeling paint has not been addressed. The violations have not been addressed. My last inspection of the property was yesterday. Boards remain, peeling paint remains. Nothing has changed on the status of the property. I would like to be able to set a compliance date.
Okay, when do we expect to have, I assume the permit you're talking about is the permit that's needed to do the repairs that are specified in the notice of violation?
Yes, sir.
When do we expect to have the permit in hand?
As soon as we can get the asbestos report back, I'll talk to the contractor about that. That's, we don't deal with asbestos as much as we used to in the construction, at least in my experience. So we're trying to get the asbestos report done so we can get the permit issued.
When do you expect the asbestos report?
Hopefully within the next 10 days is our goal.
You have who is providing it to you?
The contractor is working on that with a asbestos firm, a remediation firm, to do the testing.
So your contractor is working with somebody knowledgeable about asbestos, and you're expecting to have his report back to you within 10 days?
Yes, sir.
And then once you have that report in 10 days, what? Then we get a permit?
Then we can get the permit issued. We will have the windows on order. They're going to come finalize the measurements next week for the windows. Can't really paint until we get the other repairs and work done. That would be one of the finishing touches would be the exterior paint once we get the windows replaced and the doors replaced.
Okay. Well, this is here for us to determine a compliance date. So
yes, sir.
What do you want to propose in the way of a compliance date?
Well, the window delivery is going to be 5 to 8 weeks, which, having dealt with that with my office recently, it took longer for me to get my window, so I guess the backlog is not as bad as it was. My expectation is, unfortunately, it's probably going to be 4 or 5 months. Just because the way the construction process works with getting the permits issued and getting the windows installed.
So just to clarify, I apologize if I misunderstood. So right now you haven't given the survey yet, that you're waiting on the survey, but you have provided the additional request of the contractor information to licensing?
Correct.
Okay.
I just pulled the permit file on Friday and looked at it, and that's basically the only thing that it says is missing is the asbestos report or exemption request. Given the age of the building, I don't know that an exemption request is going to work. My expectation is we'll have to have the asbestos report done.
Since you have the report in front of you, I don't have it in front of me. What date did you apply for that permit?
The date that it shows here is April the 9th of 2025.
Okay, so this was.
And the company is Siemens, Seamans Construction. They're from here in Flagler County.
Hate to beat a dead horse, but you had time. You just did this last month.
I would just like to remind the magistrate that this violation is for this property being boarded up for over 120 days. And he's already asking for more time. We all know that this property has been boarded up for a whole lot longer than 120 days. At minimum, I'd like a progress report next month with a contract in hand of windows already have been ordered and some sort of plan on how they plan on moving forward with this, because it's not going to just be an easy take the board off and put the window in. This structure is deteriorating quickly.
I have no objection to that request whatsoever.
Additionally, the fencing on the south side and the west side of the building is in immediate need of repair.
Anything else?
Do you consider this any part of this building a safety concern?
The damaged fencing could
The damage
pose a
what?
threat because they'll be able to get in there and get
So when there's a safety concern, we can do a fine if it's not fixed within 5 days. I don't know if that's something you would like to request, but I just wanted to bring it up for the record.
What specifically is the problem with the fencing while we've got all these people right here?
On the south side, the fence is severely damaged. I mean, basically, you have to just walk over it. On the west side of the property, the majority of the fence's equipment is either damaged or not there. Another point of entry where you can basically just walk through and gain access to the property. Yes, there's an in-ground pool there. Yes, it does have a cover, but
It's had a cover there for a long time.
that's correct.
God knows what kind of shape that cover's in.
Yeah.
Agreed.
Florida statute 162.
And right now, with the fencing down, it's totally accessible.
That's correct.
And Your Honor, if I may, Florida statute 162.09 does give us the authority to do that 5-day fine if it's not fixed. Because it's a safety concern.
I assume we found this in non-compliance a long time ago.
Yes, sir.
Okay. Dennis, I want that fence fixed yesterday.
Yes, sir.
I'm going to order the respondent to have that fence repaired within 10 days or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. We will continue the balance of the matter to our June 10, 2025 meeting, once again, for the purpose of getting a progress report on the permit and to set a compliance date. And at that point in time, I'm probably, anyway, I'll just leave it at that. We expect to hear about windows, obviously. And you're telling us everything has to wait until the windows are in.
As far as the painting, yes, sir.
Well, that's a big ask, considering how aggravated everybody in that neighborhood is. That having been said, I at least have to make sure it is absolutely secure, and yes, there is a swimming pool on the property. Maybe it's inaccessible, but it makes me nervous anyway. It's right on the corner of University and A1A. It is the quintessential definition of an attractive nuisance. Anyway, enough said. Fences to be repaired immediately. We'll continue the remainder for our June 10, 2025 meeting. Good luck to you.
Yes, sir. Okay, thanks, sir.
Case number 23. I think it's, KCP Homes, LLC. Anyone here for the respondent? Not seeing a respondent, we'll say the city.
This is Inspector Ron Beanie, Code Compliance, credentials are on file. The respondent was first notified on September 16th, 2024. Since the last hearing, I've had no contact with the owner. There has been no progress to the property. Staff has recommended a fine of $100 a day at the cap of $15,000.
Respondent has been properly notified.
$100 a day to what amount?
Cap of $15,000, please.
Noting the absence of the respondent based upon the inspector's testimony, I'm finding the respondent the sum of $100 per day commencing May 8, 2025, and that fine will continue to accrue each day thereafter until the fine has reached the sum of $15,000 or the property is brought into compliance. Case number 24, Eagle Light Real Estate, LLC. Is there anyone here for the respondent?
Yes, sir, I'm here.
Yes, ma'am.
My name is
If you would
Erica
please
Tibbs.
state your name and be sworn by our secretary.
Yes, sir. My name is Erica Tibbs. I'm the business manager for Eagle Light Real Estate.
Raise your right hand. You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, ma'am.
Thank you.
And I'm sorry, your last name again?
Timms.
Are you saying Kim?
No, Tim with a T. Tango Hotel India Mike Sierra.
All right, this matter is here for the imposition of a fine. What say the city?
Respondent was first notified on August 12th, 2024. Since the last hearing, I have had contact with the owner, which is I've received a letter that was created by a mortgage company called Loan Factory. The letter states the refinancing is in place and should be finalized in approximately 45 days. During the closing, the funds owed to the city will be dispersed. There has been no progress on this case. Staff has recommended to amend to the July cutoff.
What funds are payable to the city? Did we previously fine this respondent?
No, it's money due to previous owners doing some work, and this owner happened to get
All right, so in any event, you wanted to amend to the next cutoff?
Yes. July cutoff, please.
July cutoff.
Yes.
Okay, the city is proposing amending your current order of noncompliance to allow you to July 2, 2025 to come into compliance. What say you to that?
I believe we'll be fully in compliance before then, and I appreciate that from the city. We're doing everything we can.
Very good. Then I will order our previous amended order of noncompliance amended to extend the compliance date to July 2, 2025, or the respondent will be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck.
Thank you.
Case number 25, R&J Estates, LLC.
Good morning.
Yes, ma'am. If you would please state your name and be sworn.
My name is Rosa Alvarado.
You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
This matter is here for the imposition of a fine, so let's hear from our inspector.
Mariah Quinn, Inspector with the City of Daytona. My credentials are on file. The respondent was first notified on November 8th, 2023. Since the last hearing, I have had contact with the property owners. The property remains unoccupied, and the property is going through the application process for the Elevate Florida program through the Florida Division of Emergency Management. They have not received their determination yet, so staff recommends amending to the July cutoff for them to get a determination.
Is this the house that we have to lift up?
Yes.
Okay, so you're agreeing to an extension to where now?
Yes, sir, to the July cutoff.
Okay, the city is proposing to amend your current order of noncompliance to extend your compliance date to July 2, 2025.
Okay. Thank you
That's
very much.
okay with you?
Yes.
Okay. All right, I will amend our current order of noncompliance to allow the respondent until July 2, 2025 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Thank you. Thank you very much.
Case number 26, Gregory Karpinski. Anyone here for the respondent?
Yes.
Yes, sir. If you would state your name and be sworn.
Gregory Karpinski.
Raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
All right, this matter is here for the imposition of a fine, so let's hear from our inspector.
The respondent was first notified on January 18th, 2024. I have had contact with the property owner. The property is occupied by the owner. Since the last hearing, the notice of commencement has been filed with permits and licensing, and staff is recommending amending to the next cutoff.
Okay. Does that sound agreeable to you?
I agree.
Okay. Just give me a thumbs up or something if you can't talk. Okay. All right. I'm going to amend our amended order of noncompliance to allow the respondent until June 4, 2025 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Good luck to you.
Thank you.
Case number 27, Uzair Shuja. Anyone here for the respondent? Not seeing a respondent. What say the city?
Inspector Garcia, credentials on file with city. The owner was first notified of all violations on January 22nd, 2025. Since the last hearing, I've had contact by email only. Property is occupied. There has been no progress. Staff's recommending a fine of $200 a day, capped at $15,000.
Respondent has been properly notified.
Noting the absence of the respondent, based upon our inspector's testimony and the photographs presented, I'm fining the respondent the sum of $200 per day commencing May 8, 2025, and that fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property's been brought into compliance. Case number 28, Florida, LLC. Anyone here for the respondent?
Respondent has been properly notified.
Not seeing a respondent, what say the city?
The owner was first notified of all violations on December 30th, 2024. Since the last hearing, I have had no contact with the owner. Property is not occupied. There is no progress being made. Staff's recommending a fine of $100 a day, capped at $15,000.
Did you say 100?
Yes, sir.
Noting the absence of the respondent, based upon the photographs presented, I'm fining the respondent the sum of $100 per day commencing May 8, 2025. The fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $15,000 or the property's been brought into compliance. Case number 29, S&O Investment USA LLC. Yes, sir.
Morning.
If you would state your name and be sworn.
Steve Turiaga.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes, ma'am.
Thank you.
All right. This matter is here for the imposition of a fine. What say the inspector?
Inspector Curtis Wiggins, Code Compliance, credentials on file. Respondent was first notified of violation February the 16th, 2024. Since the April hearing, permit was issued. I've had contact with the owner. Staff recommend a compliance date.
Staff recommends a compliance date of?
I want to hear what the defendant got to
Planned
say.
poker
Yeah.
here.
Yes, sir. We got the permit last month. It was a long time getting it. We've been working with the utilities to have the utilities removed. We just got the electrical permit last week. And so by next month, I think we should have the building down and should be in compliance.
Next month is June 4th.
Yes, sir.
Sounds like he's done everything you've asked him to do.
Correct.
Is June 4th cutting it close?
Cutting close, but like I said, we talked. He did say he should have that portion of that building demolished.
All
So
right.
yes.
I guess I won't rock the boat. And I'll amend our current order of noncompliance to allow the respondent until June 4, 2025 to come into compliance or be returned to the special magistrate for consideration of fine of up to $1,000 per day. I'm sure you know the drill. If you run into a problem, call your inspector.
Yes, sir. Thank
Good
you.
luck to you.
Thank you.
Case number 30, Denise T. Diabato. Anyone here for the respondent? You would state your name and be sworn.
Denise Stabato, 611 Braddock Avenue.
Swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
This matter is here for the imposition of a fine, so let's hear from our inspector.
All right. Respondent was first notified of violation February the 11th, 2023. Since March hearing, no progress has been made. I've had contact with the owner. The last date of the reinspection was May 7th, 2025. The result of the reinspection was non-compliance, so staff recommend a fine of $100 a day to a cap of $10,000.
Where's our contractor?
He quit, I guess. I haven't heard from him. The permit's expired. I've paid him.
Okay. What are we going to do about completing, what work is left to be done?
The entire deck.
Everything.
Yeah.
All right, what are our plans for that?
I don't know. I don't think that we can get another contractor to come and take over somebody else's work. They're really not supposed to do that because of insurance reasons. So we need a permit. My boyfriend has been doing the best he can to work, make some repairs, but he works full-time, so he's only been able to do it on the weekends. I don't know how we can get a permit. Somebody told me, right, currently the status of the building is a triplex. It has not been 3 usable units in many, many years. There's the upstairs that we live in, and off to the right is a finished apartment that my father-in-law now resides in. But where you can see that white door on the bottom, that second or that third unit is been vacant forever. So I was told that if we weren't 3 units, but just 2 units, then we would be able to pull our own permit and do our own work. Is that correct?
Well, I don't know. I'm not the person to ask. I'm trying to figure out where you go from here.
If that was true, I had plans to go to the building department right after this and talk to them.
Okay, what you've been cited for is a dilapidated deck stairway. Do we still have the dilapidated deck stairway?
Yeah, everything is there. Yeah, the whole deck itself needed to be, well, they was going to replace the entire deck. Like I said, this started actually in 2020, this deck here. When I took over, like I said, in 2023, about this same deck here, there have been different permits that has been pulled, extensions, reinstatements, and now this permit that they just had was reinstated, well, extended in January of 2025, and this just expired again in May 2nd, this permit. So now there's no permit to do anything else. But it's been about 4 or 5 different reinstatements and extensions.
Do you live on the second floor?
Mm-hmm.
How do you get there?
The ladder.
The ladder.
You climb the ladder to get to the second floor?
Mm-hmm.
Okay, what's your game plan? I don't think you're going to keep climbing a ladder forever.
Oh, God, no.
I mean, I'm afraid to ask, well, never mind. You climb the ladder to get to the second.
Can I ask a question? You mentioned, is that all right, Your Honor?
Yes.
You said you're not sure if a contractor will take over another contractor's work, but have you actually called contractors to ask? Because, you know,
All right, well, I've already paid $22,000 and no work has been done. So, I mean, that was the best bid that we got. The other bids were like upwards to $50,000.
How many contractors have you called?
We had like 8 different bids.
Okay.
I'll take any suggestions from anyone.
No, I
Well,
was
my
just trying to
concern
see.
here is at
see
some
if-
point, the city may be stepping in and telling you the place is uninhabitable. If you're telling me your only access to the second floor, which is the primary occupied unit, is by ladder. Well, I'm not allowed to do nothing. That having been said, I'm going to continue the imposition of this fine to the June 10 meeting to give you time to try to figure something out. If by June 10, we're in the same boat we're in right now, with nothing having changed, then I'm not going to have any alternative but entertain this gentleman's job required request for a fine. So, I feel for your circumstance, but we're going to have to figure something out here.
Okay.
And my concern for you isn't even here. At some point, I don't think the city's going to let you keep climbing up and down a ladder to get to a second floor living unit.
Okay.
All right. We'll hear from you on June 10th, and hopefully you'll have something positive to share with us so we can go from there.
Okay.
Otherwise, we will have run out of alternatives. Good luck to you, ma'am.
Thank you.
Case number 31, Pelican Bay Sports Club, LLC. Not seeing a respondent. What say the city?
This property was first notified on January 9th of 2025. Since the last hearing, I've had contact with the property owner. There was no progress towards compliance. The city is requesting a daily fine of $250 a day, up to $20,000.
The respondent has been properly notified.
Noting the absence of the respondent, based upon the inspector's testimony and the photographs presented, I'm finding the respondent the sum of $250 per day.
Thank you.
Commencing May 8, 2025, and the fine will continue to accrue each day thereafter until the amount of the fine has reached the sum of $20,000 or the property is brought into compliance. Case number 32, Panora Properties, LLC. Is there anyone here for the respondent? Not seeing a respondent. What say the city?
Inspector Atanico Compliance, credentials are on file. Respondent was first notified on May 25th, 2024. Since the April hearing, I had no contact with the owner. However, there was a permit that was issued on May 6th, 2025. Last inspection was May 12th, 2025, and the result was non-compliance. Staff recommends we amend to the next cutoff to allow time for the final inspection, since he just got his permit.
All right. Noting the absence of the respondent, based upon our inspector's testimony and recommendation, I'm amending our current order of noncompliance to allow the respondent to come into compliance by June 4, 2025, or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter. Case number 33, 1995 Big Island Trust, dated August 8, 2020, and Tyler Anthony Vasquez Trust. Anyone here for the respondent?
Yes, sir.
Yes, sir. If you would please state your name and be sworn.
Anthony Vasquez.
state his name? Did you
Yeah, he
state
did.
Raise your right hand. You swear from the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Okay, I believe you're supposed to give us a progress report.
Yes, sir. As of yesterday, the 12th, I received 2 of the 3 building permits at 123 and 125 South Wild Olive. And my architect and engineer is working on the architectural and structural plans for 314 Aura Street. I have a letter here from the architect stating so.
Okay,
We got to talk about Aura first, and then we'll move on to Wild Olive.
Sure.
all right, right now we're at 314 Aura. So what does all that mean as far as Aura goes?
He just gave a paper saying that his architect is working on the drawings for it.
I have a copy if I could give it to you as well, Your Honor.
Okay, this is, all right, so what are we doing? We're in the process of applying for a permit?
Yes, sir. The last time we met, I had an asbestos company remove the asbestos. That's where we're at the last time we were here. Since then, I've hired a licensed architect and engineer for all 3 properties to do the plans. Unfortunately, he did Wild Olive before he did Aura. So I have the permits for Wild Olive, and I'm still waiting for the plans for Aura.
What say the city?
So my last inspection was May 12th, and I was just asking for another progress on the next cutoff for these.
Okay, then that's what we'll do. I'll order that this matter be put on the June 10, 2025 agenda for us to get a progress report. Hopefully, we'll know more about a permit by then and be able to start talking about a compliance date. Okay, case number 34. 1995 Big Island Trust dated August 8, 2020, and Tyler Anthony Vasquez Trust. This is 123 South Wild Olive Avenue. What's the progress there?
Me or?
Permits are in place.
Permits are in place?
Yes, sir.
Great. You have any idea when the property's going to be in compliance?
We just got the permits yesterday. I'll be coordinating with the contractor to start work.
All right, and do we have any idea how long work is expected to take?
I don't. It's going to be rather extensive. I don't know if you recall the photos there. The termite damage and the dry rot's rather extensive, so we're going to have to shore up the one portion of the house, remove the wall, reframe it, go to the next portion, shore it, reframe it. So it's going to be a step-by-step process.
Since you're going to be here on June 10th anyway, we'll have another progress report on this property on June 10th as well.
Sounds good.
Very good. All right, good luck to you. Case number 35, Covenant Community Development Corporation of Florida, LLC. Anyone here for the respondent? Not seeing a respondent, what say the city?
Mark Jones, Field Supervisor. My credentials are on file. Respondent was first notified on April 5th, 2024. Since last hearing, there has been no contact from the owner, but I did have contact with the asbestos inspector from Samsula Demolition. There is a demolition permit submitted. It was submitted on April 25th. Staff recommends amending the order of compliance to the next cutoff.
Okay. Noting the absence of a respondent, based upon our inspector's recommendation, I'm amending our current order of noncompliance to allow the respondent till June 4, 2025 to come into compliance or be returned to the special magistrate for consideration of a fine of up to $1,000 per day thereafter.
Thank you.
We've already dealt with the miscellaneous business. Is there anything else to be brought before the special magistrate?
No, Your Honor, thank you.
Pardon?
Yeah, yes, we do have somebody who, hold on just a second,
No.
what?
Well, it can be heard, but it's not on the agenda.
They wanted to submit some information for a lien review. I didn't get the information until yesterday, so it was not placed on the agenda, so they're asking to be heard.
But I want to clarify that it's the city's position. It's your discretion what you want to do, but this would be deferential treatment to everyone else. Our standard process is that we give me time to look. I just received this application today, so I haven't had proper time to review it. Generally, when we get the application, we put it on the next agenda to give legal proper time to review it. So they can be heard for due process, but an order, we recommend that an order be waived so that this can be put on the next agenda. Because
Gentlemen, I'll hear you, but you're
wasn't
actually
timely.
going to do yourself a disservice by doing this. Because
I just received this today.
they have a right to be heard, and so we can put it on the very next agenda.
Since we've done the compliance,
Pardon?
since we are in compliance, like everything is done and everything is good, and what's the projection that's like to finish it today? Why they are not finishing?
Because it reached the point where I felt the need to impose a fine, and the purpose of the lien review isn't to tell me you're in compliance. We expect you to be in compliance, or else whatever the structure is would have been eliminated by now. The purpose of the lien review is to explain your extenuating circumstances as to why you were unable to bring it into compliance when you were supposed to. And if you can convince me that there is a meritorious argument there, then I will consider perhaps a reduction and/or elimination of the lien. And in addition to that, we also have a process in place whereby you can communicate directly with the building department to try to resolve a lien review amicably. I don't want to promise you anything, but my experience here has been that liens have been amicably resolved with substantial payments, partial payments, no payments. So I'm not predicting what the outcome is of your particular circumstance because I don't know anything about it, but that's a process you ought to take advantage of.
Yes.
Because if you just come in here cold, giving me one side of the story, odds are I'm not going to making any rule. I won't be making any ruling at all today.
And if I may, Your Honor, it's very likely that we could dismiss it or come to some settlement, but I can't tell you that because I don't know the facts, and it wouldn't be fair to other people who give me the lien review on time and give me time to review it. I just can't, for fairness of other applicants and just myself to have time to properly review it and staff, it's just to be put on the next agenda. As I told you at the beginning of this, I feel bad that you waited. You can be heard, obviously due process, but we can't rule on it now. I mean, I suggest it's the magistrate's discretion.
April 2nd, so we thought
Well,
maybe.
let me also, what I'll also say is for the sake of accommodating you, I doubt we need all three of you to come back. So if you want to appoint a spokesman, that would be acceptable to me.
Okay.
Now, if all three of you want to show up and be sworn and testify, I'm not going to deny you your right to do that. All I'm saying is, for the sake of convenience, you're welcome to appoint one person as the spokesperson, and I'll assume he speaks for all of you. Anyway, that having been said, I would suggest you put it on an agenda. You might find the pre-settlement conference helpful. If not, then I'll hear it. And if it has to be heard, I don't mind hearing from just one of you as opposed to all three, but you're all welcome to come back and say as much as you want.
Thank you, Magistrate.
All right, good luck to you.
Thank you. So
Do you want my card so you can reach out to me?
Yes, please. So June 10th?
We can have a meeting at your earliest convenience and with staff.
What you saying, dude?
At the end of the day, so we're the ones to make the decision. I'll facilitate that, but
Thank you. Thank you.
I would prefer an approval.
Okay.
Good luck.
Thank you.
We're adjourned.